Good morning, everybody. You're welcome. My name is Fergus McMahon. I'm the Department Manager in Enterprise Ireland's high-tech construction industry. I'd like to welcome you all here to this morning's webinar, where we break down the latest changes on the latest EU data regulation and what it means for Irish SMEs. This is the fifth session of a six-part series delivered in partnership with Vulcan Consulting. It's really designed to help you navigate the evolving and European national policies. The goal of this series is to kind of demystify complex legislation and provide you with practical insights. Over the next hour, we'll unpack what you need to know about the EU Data Act and answer any questions you may have. So I think we have a really good panel of speakers here today. To begin with, we both have Conor and Hana from Vulcan Consulting, followed by Laura Clifford from Enterprise Ireland, and Dr. Patrick Cronin from the Irish Manufacturing Research Centre. If you do have any questions during the session, please put them in the chat function available. And we'll have time at the end. We'll try and get to a number of those. We also like to note that this session will be recorded. So I'm going to hand you over to get us started. Conor and Hana, please take over.
Thank you, Fergus, for your introduction, and thank you to everyone for joining us today. We are Vulcan Consulting, an Irish consultancy with offices in Dublin, Brussels, and Belfast, where we help organizations navigate what Brussels produces and what Ireland implements, and what businesses must do on the ground to stay competitive and compliant. So we work across health, digital, life sciences, data, of course, energy, and the wider EU regulatory landscape. And we are delighted to partner with Enterprise Ireland for this webinar series. Today's session is all about the EU Data Act, one of the most consequential EU digital law for companies working with connected products, data-driven services, cloud infrastructure, and the Internet of Things. The goal today is very simple, to turn a complex EU regulation into a practical roadmap that Irish SMEs can actually use. My name is Hana Bártákova, and I'm the head of our Brussels office. I've spent more than 12 years inside the EU ecosystem, from the European Parliament to advising businesses and trade associations on legislation that shapes how data is governed and how companies scale across the single market. So I'll now hand over to my colleague Conor for a short introduction before we dive in.
Hi everyone, thanks very much, Hannah. I'm Conor Horgan. I'm an account executive at Vulcan Consulting based in our Dublin office. So I focus mainly on helping our clients navigate Ireland and political regulatory landscape. So I'll pass you over to Patrick now to introduce himself.
Thank you, Conor. Yeah, Dr. Patrick Cronin. I'm the Senior Programme Manager in Irish Manufacturing Research based in Racool and Mullingar. Within the digitalization team that I work within, we serve electronics, IoT, OT, IT, and also data and AI. So this is a very apt and necessary topic for us today. Thank you.
Good morning, everybody. I'm Laura Clifford. I'm the Senior Programme Manager of the European Digital Innovation Hubs here in Ireland, and I'm based at Enterprise Ireland in Dublin.
Perfect. So we'll start it off. So looking at the bigger picture, when we're talking about the EU Data Act, we're really talking about kind of a shift in how Europe thinks about data as an economic asset. So for the last decade or so, we've seen connected products become embedded in almost every sector. So manufacturing, transport, medtech, energy, consumer devices. So every one of these products generates data all of the time. And the question the EU began asking was essentially who actually benefits from all this data. So historically, the answer has been the entity that technically controls the system, which would be the manufacturer or the platform provider or a cloud host. So the Data Act aims to change that. So it being a regulation means that it applies directly in every member state. It doesn't need to be transposed into Irish law like a directive, so it just becomes a part of the landscape. So the objective is to establish kind of a harmonized EU rules on who can access, use, and share data generated in the European economy. particularly data generated by connected products and related services. So it does so with the very deliberate goal, which is to ensure fair allocation of data value among the stakeholders involved. So it's kind of important to position this properly rather than focusing on personal data protection like GDPR does. The data focuses on how data can be accessed and used within the economy. So the Act itself sits at the center of Europe's push for digital competitiveness and digital sovereignty. So the EU recognizes that data is a core input into AI, industrial optimization, supply chain resilience, and innovation. So for Irish SMEs, particularly those operating in digital, IoT, analytics, or manufacturing supply chains, this isn't just an abstract Brussels policy making. It directly affects your commercial models, contracts, and system design. And so naturally that leads us into our next question, which is what exactly does it cover? So narrowing down the scope, the Data Act applies to both personal and non-personal data, but only in defined contexts. So it is targeted at data generated by connected products and related services. So we're talking about machine generated data that's produced through the use of connected equipment or services linked to that equipment. So that could be a connected tractor generating performance data, a smart energy meter generating consumption data, or a medical device generating operational logs. It also applies to the services that process or interact with that data. So your software layers, your cloud services, analytics platforms. So importantly, the Data Act works alongside GDPR. So if personal data is involved, GDPR still continues to apply. So the Data Act doesn't override privacy protections. There are a few exclusions. It does not apply to voluntary data sharing arrangements. So if companies decide freely to share data outside of the Act scope, that remains possible. And there are areas that it explicitly excludes that are sensitive public interest domains, such as national security, defense, law enforcement, customs, and taxations. Those remain within national competence. So what we have here is a cross-sectoral but economically focused regulation that's about industrial and connected product data in the internal market. So now that we've gone through the scope, the next step is to understand who the Act actually regulates. So this is generally where businesses underestimate their exposure. So the Act defines a range of actors, manufacturers of connected products, providers of related services, providers of data processing services, users, data holders, data recipients, and public sector bodies in a few exceptional circumstances. So what you really need to understand, though, is this. The Act attaches obligations to the role you play in relation to data, not your company label. So you might not think of yourself as a manufacturer, but if you produce a connected device, you are one under the Act. And you might not think of yourself as a data holder, but if you technically control access to a data set, you likely are one. You might receive machine data from a manufacturer to build an optimization tool, and in that relationship, you're the data recipient with all the obligations attached. In another relationship, you might hold processed data and become a data holder yourself. So the first practical takeaway for any SME is to map where you sit in the data value chain, because the rights and obligations differ depending on your position, which brings us to the two central legal roles that drive much of the regulation. So the two most important concepts in the Act are your data holder and your data recipient. A data holder is an entity with technical or legal control over the data. So if others must rely on you to gain access, you likely are the holder. And data holders have structured obligations. They must provide access under certain conditions, ensure the data is provided in a structured machine-readable format. You must protect trade secrets, implement security safeguards, and you may be entitled to reasonable compensation in some business contexts. A data recipient, by contrast, is the entity that receives data from a holder, and this also comes with clear conditions. Recipients must use the data only for agreed purposes. They must respect contractual and legal conditions. They cannot misuse data to compete unfairly with the holder, and they cannot bypass technical protections. So this is where the Act becomes a bit more nuanced. It creates access rights, but it does not create open access. So it's kind of balancing empowerment with protection, But it's important to remember that obligations are attached to control over data, not the actor itself. You can both be a holder and a recipient in different relationships. So an SME controlling valuable niche data is just as much within the scope as a multinational company. So now that we've gone through the roles, we'll have a look at the ecosystem as a whole. So the Data Act regulates the entire ecosystem around connected products. So at the start of the chain, you have your producers. So these are the manufacturers generating product data. Then facilitators or enablers. These are providers of related services and data processing services. This layer is particularly relevant in Ireland, where many of the SMEs operate in software as a service, analytics, and cloud integration. Then you have your beneficiaries, who are the users and participants in data spaces. And finally, public sector bodies. But as mentioned before, this is only in tightly constrained, exceptional circumstances. So what the regulation tries to do is a rebalancing of the ecosystem. So users gain clearer rights, access to data generated through the use of their products. Producers retain protections for trade secrets and security. Facilitators must enable system compatibility and switching. Cloud providers must reduce barriers to switching between services, which helps tackle being locked into one service. Public authorities may request data only in public emergencies and must delete or return it afterwards. So it's not an anti-business regulation, it's more of a market structuring regulation. So it tries to ensure that value flows through the chain rather than being locked in at a single control point. So I'll now pass you over to my colleague Hana, who will take us through the next part, the part that most businesses care about, which is what does this actually mean commercially?
Thank you, Conor. So we are now going to dive a little deeper in the different categories, starting with the producers, so the manufacturers of connected products. So first, producers must provide user access to products and service data. So in plain terms, if your product generates data through its use, the user has a right to access that data, and producers need to make that data access possible. Secondly, producers must ensure data sharing while protecting trade secrets. So the law is trying to strike a balance here. Users can access and share data, but producers are still protected against losing confidential business information and proprietary know-how. Thirdly, producers must comply with lawful public emergency requests. So we are going to talk a little bit more in detail about that later, but this links to public sector access, part of the Data Act. It exists, but it is designed to be exceptional and not routine. Producers must also prevent unlawful international government access. And this is a big theme across the EU digital law. If data is held in a way that could expose it to unlawful third country access, companies are expected to take all the necessary steps to prevent that. Finally, producers are often the initial data holder, so meaning they are the party that has the technical control over the data first, which is why the Data Act places many of the first obligations on them. So the takeaway from this is that the Data Act is not only about what users can ask for, it is also about what producers must build and what they must enable, and it explicitly recognizes trade secrets protection and safeguards against unlawful access. So here we zoom in on facilitators, meaning the providers of related services or data processing services. This category is really important because many SMEs are the manufacturers of the physical product. Instead, they sit in the software and service layer around connected products. So facilitators must enable secure data access, processing, and interoperability. That means that if you are providing the related service or you are providing the data processing layer, you have to support access in a secure way and in formats that can actually work across all systems, because otherwise the Data Act rights are meaningless. Facilitators must then support switching between providers, and this is the cloud switching and portability part of the Data Act. The law is designed to reduce lock-in and make it easier for customers to move. Thirdly, facilitators must use transparent contracts reflecting Data Act obligations. So we are not just talking about technical duties. Contracts and commercial terms need to match the new legal reality. And again, facilitators must prevent unlawful international government access. This is the same cross-cutting theme as we saw in the producers. They are usually recipients first and then holders of derived or processed data. So in other words, they may receive raw data from producers and then become holders of the processed data set, analytics outputs, or derived data products. This is exactly where many SME business models would sit. Value-added services on the top of machine-generated data. So if you provide a service layer or processing layer, the Data Act matters just as much for you as it does for hardware manufacturers, because you may be the party enabling access, enabling switching, and creating derived data. The category of beneficiaries includes users, data space participants, and smart contracts. So what are beneficiaries expected to do and what they are able to do? So first, beneficiaries should be able to access, use, and share data lawfully. That's the core user right aspect of this regulation. Secondly, beneficiaries should be able to switch service providers without obstacles, again, linking directly to portability and cloud switching requirements. And thirdly, they should be able to expect interoperable formats and technical standards. So this is important. The Data Act is not just about permission, it's also about usability. So the data has to be accessible in a way that works across systems. The beneficiaries must also respect reuse conditions and smart contract safeguards. And this is the part that people often miss. It's not a free-for-all. If you receive data, you have obligations about what you can do with it, how you can reuse it, and what conditions apply. And if smart contracts are used in the data sharing mechanism, you have to respect the safeguards built in it. So in short, there are new opportunities to access data. But if you want to be a data recipient or build services on top of shared data, you also have to be able to demonstrate lawful use and compliance with the conditions. Last but not least, public sector bodies, European, national, regional, or local services may request data only for exceptional needs. So it's not routine access, as we said before. This is designed for specific situations, such as emergencies or serious public interest needs defined in the regulation. For example, we are talking about natural disasters, large-scale power grid failures, major cybersecurity attacks, etc. Any such request must be strictly necessary and proportionate, and the data can only be used for that specific public purpose defined in the request. Trade secrets and data protection rules must be fully respected, and the data must be handled securely with appropriate safeguards in place. And once the situation has been addressed, the data must be deleted or returned. So in other words, the system is designed to allow strictly limited and exceptional access, not to create ongoing or permanent state access to private data sets. So if SMEs are worried about will the government now be able to take our data whenever it wants, the answer is no. It's exceptional, constrained, and time limited. And to pull all of this together, it can help to think about a simple everyday example. So a connected car and the services around it. So in this ecosystem, the car manufacturer is the producer. It designs and sells the connected product, and the car generates data every time it is used. So things like diagnostics, energy use, performance data, etc. The facilitators are then the companies providing the software and infrastructure around the car. The mobile app, the backend analytics platform, the cloud services that store and process the data. They don't manufacture the car. Well, sometimes they do, but in this example, let's say that they don't. But they enable access, processing, and switching, which is why the Data Act places obligations on them as well. The beneficiary is the user, so the driver or the fleet operator, who generates the data through everyday use of the car. Under the Data Act, that user has the right to access their data and to decide whether it should be shared with a third party, like, for example, an independent garage or a fleet management provider. And this third party can receive the data, but only for the specific purpose approved by the user and under very strict conditions. So they can't reuse it freely or resell it or undermine the producer's trade secrets. And finally, we have the public authorities that sit at the edge of the system. They can only request access to the data in exceptional circumstances for clearly defined public interest needs, and must delete or return the data once that purpose is fulfilled. So this one example shows that the Data Act is really doing what the Data Act is really doing across the value chain. So it doesn't target only one type of company. It assigns rights and responsibilities depending on your role and on your place in the chain, balancing user control, producer protection, and space for innovation. So the Data Act entered into application on 12th of September 2025. So as we sit here in February 2026, this regulation is already applicable. It's no longer a future framework. That means the core obligations we just discussed, user access to data, user-directed sharing, etc., are part of the live compliance landscape. However, the regulation also includes important transition measures. Existing contracts that were concluded before 12th of September 2025 are not automatically invalidated. Certain contract terms provisions will apply to those contracts only from 12th of September 2027, giving businesses time to review and adjust long-term agreements. And in addition, the cloud switching and data processing services obligations are also phased in. Providers must already enable switching, but charges and technical restrictions are gradually reduced over the transition period, with full removal of certain switching fees expected by 2027. So the timeline is not a single compliance cliff edge, it's a stage adjustment. And the practical implications for SMEs is this. So while some contractual and cloud portability elements have a transition window, the strategic direction is already clear. This is no longer, let's see what's happening in Brussels, let's monitor Brussels situation. It is what we need to identify where we sit in the data chain and start aligning contract systems and partnerships accordingly, because everyone, customers, partners, and large supply chain actors are already adjusting their terms to reflect the Data Act. So this is a regulation, yes, but it is a regulation with a simplification goal. So first, it creates a consolidated and coherent EU data framework. The point is to reduce fragmentation and uncertainty across member states and sectors. And secondly, it confirms that business to government access is restricted to public emergencies. That reinforces what we just said, that this is not a routine government access. There is also support for SMEs and pre-existing contracts, meaning the EU recognizes the burden and has tried to design proportionality and transition measures. And it is also important to note that the Data Act does not operate in isolation. It fits into a broader integrated EU data governance architecture that has developed over the past few years. So we have the General Data Protection Regulation, the GDPR, that governs the protection and lawful processing of personal data. We have the Open Data Directive that regulates the reuse of public sector information. We have the Data Governance Act that creates mechanisms for trusted data intermediaries and voluntary data sharing, including also data altruism. And then we have sector-specific regimes, such as, for example, the European Health Data Space, which build tailored data sharing frameworks for particular industries. And the Data Act fills a different space in that system, as it focuses specifically on access to and sharing of data generated by connected products and related services, particularly machine-generated data, and on reducing lock-in and data processing services. So together, these instruments create a layered structure. One layer protects personal data, another governs public sector data, etc., etc. And the Data Act ensures access and portability for connected product data. Companies therefore need to understand not just one regulation, but how these layers interact depending on the type of data and their role, the role they play in the value chain. The practical implications here are that you need a coherent data strategy that understands which regimes applies to which data set and when. And the EU is building a structured data economy, not isolated rules, and the Data Act is one of its central pillars. And finally, Governance and oversight are strengthened. So the European Data Innovation Board, Commission decisions, and SME-focused evaluations are put in place. So the EU intends to monitor how this works in practice and adjust based on evidence, and especially for SME impact.
Brilliant. Thank you very much, Hannah. So we're going to shift more from the structure of the Act to the strategy. So what are the opportunities here? So first, we have improved access to product data. So historically, if you were an independent service provider, say a predictive maintenance company, accessing machine-generated data could be commercially difficult. So the Data Act clarifies that users can request access and direct sharing with third parties. That potentially opens up space for SME to build value-added services on top of existing connected products. Second, we have new data-driven revenue models. So if access barriers are reduced, SMEs can develop analytical tools, optimization services, insurance models, benchmarking platforms, all leveraging the data that was previously siloed. Third, we have reduced dependency on dominant cloud providers. So the Act includes switching and system compatibility obligations for the data processing services. So that strengthens the negotiating position of customers, including the SMEs. Fourth, we have stronger position in commercial negotiations. So the regulation addresses that unfair unilateral contractual terms relating to data and access use that had been there previously. So that's particularly relevant for SMEs dealing with larger counterparties. Fifth, we have harmonization across the EU. So instead of navigating fragmented national approaches to industrial data access, SMEs now operate within a single EU framework. So for Irish companies seeking to scale into the European markets, that legal predictability is incredibly valuable. So the regulation is not just compliance, but it's also competitive positioning. Now, of course, with all the opportunities, there are also a number of responsibilities that come along with it. So if your product generates data, you must ensure users can access it. That access has to be structured and machine readable and secure. Contracts may need revision, particularly around data access clauses, termination rights, liability allocation, and switching terms. Technical systems must be capable of secure sharing and portability. So it's not just a legal review exercise. You may need your IT and operational input teams involved. Customers will increasingly expect data access as standard, not an exception. And there are a number of enforcement mechanisms. Member states will designate competent authorities. Penalties need to be effective, proportionate, and dissuasive, and administrative fines are possible. So the question isn't really for SMEs is whether or not to engage, but how to proactively engage. So the businesses that treat this as a strategic alignment exercise rather than a last-minute compliance task are likely to benefit the most from the shift the Data Act represents. So the natural question at this point is what should you be doing right now? So the first step is internal visibility. You need to identify what data you generate, what data you control, and what data you rely on from others. Many organizations are quite surprised when they map this out properly because data flows are often way more complex than expected at first. Second, you need to review your contracts. So look at agreements with suppliers, customers, cloud providers, and partners. Are there clauses there that restrict data access? Are there unilateral modification terms? Do switching providers align with the new portability requirements? So it's not about rewriting everything immediately. You just need to identify where you're exposed. Third, assess your technical readiness. So if a customer requests access to machine-generated data, can you provide it in a structured machine-readable format? Is that access secure? Can you separate your trade secrets from user-generated operational data? So they're all, as I said before, operational questions, not just legal ones. Fourth, you need to engage with your key vendors early. If you rely on third-party cloud providers or embedded systems, you may depend on them to meet portability or system compatibility requirements. So your early engagement will reduce your risk later on. And finally, you need to assign internal ownership. So the Data Act touches legal, commercial, technical, and product teams. So you need someone who's responsible for coordinating compliance and strategy. So the message here is very practical. You need to map, review, assess, engage, and assign. So your proactive engagement right now will make it significantly easier than your reactive correction later on. Now, of course, you're not expected to navigate all this on your own. So Enterprise Ireland is here precisely to support Irish SMEs in understanding how European legislation affects competitiveness and growth. At an EU level, the European Commission has already published guidance and FAQs to clarify the regulation's intent and structure. At a national level, you'll have competent authorities who will play a role in enforcement and interpretation. So these will be bodies such as ComReg, the Competition and Consumer Protection Commission, and the Data Protection Commission where relevant. So there is an emerging ecosystem of guidance and oversight for this. But the main point is the Data Act is part of kind of a wider EU digital framework. So engaging early with available supports, whether that's through Enterprise Ireland here, sector associations, legal advisors, or regulatory guidance, that will allow businesses to treat this as an adjustment for your business rather than a compliance shock. And that will position far more strongly in the medium term to deal with this. And I will now pass you over to Patrick for the rest.
Thank you, Conor and Hana. I'm in the unfortunate position of going after both of you after a very comprehensive overview of the EU Data Act, but I will try and, I suppose, align some thoughts around the manufacturing space and what we see and what we're hearing from industry in terms of the EU Data Act. So next slide. Again, there's probably a little bit of overlap here, but I'll just focus on a couple of points. And one of those is that historically, the vast majority of industrial IoT data, almost 80%, has been locked out from being used or been accessed. And I know that myself from having worked in the process industries where typical vendors or suppliers of sensors and technologies wouldn't allow access to data that's been generated from those. So I suppose with that in mind, about 90% of all data within a manufacturing site is OT data or operational technology data, and about 10% is IT data. So think about all that data in a manufacturing site that's been locked out. And that's the opportunity here. So when I was telling my wife this morning, I was doing a webinar on the EU Data Act. She's asked me how am I going to make it exciting? You know, and I asked Gemini this morning, and it seems AI can't even solve that problem. But I suppose the exciting part sits within the opportunity that exists. And just yesterday, the Taoiseach announced the update to the National AI Strategy. And within that, he calls out the EU Data Act as an opportunity. It's an opportunity for manufacturers, for vendors, for suppliers to access data and to be able to utilize that data to generate additional either product or process or opportunity revenue. And they estimate that it's up to about 270 billion that's available within the EU once we unlock all this data. So that's typically the opportunity that exists, and it allows and it enables vendors and users to access data that may have had large regress fees from the large cloud-based software companies such as AWS that would have locked out a lot of people from data that was being generated on or in their products or their person and so on. So not to duplicate a lot of Conor and Hana's information, but I suppose the major milestone here is that September 12, 2026, where there are requirements for new products to have access by design requirements built in for data. And that's a key milestone there. And I suppose a lack of what we're hearing within the market, and that concerns me, is that people don't yet know or don't understand what the EU Data Act means for them, their products, their facilities, and so on. So next slide. So who does it impact? We've already had the discussion. I'm more focused on the manufacturing level. You're talking about data concerning the devices or the use of their environment, smart factory machines, industrial sensors, med devices, related services or targeted sectors, so IoT providers, cloud edge services, and any data that covers those personal and non-personal data that's been covered already by Conor and Hana. So if we go to the next slide. So ultimately, it'll be access on request, so users can request access to all usage data free of charge. And there's enablement for third-party portability into different infrastructure where they can access that data as well, and can be utilized. And it's a real-time requirement, so basically they can directly access that. They can get real-time access to it, either through dashboards or APIs that they can leverage into different pieces of electronics equipment generating data. So next slide. However, when you look at what that means for protecting IP and trade secrets, there is the trade secret shield. So companies are not required to disclose any intellectual property where that data has been taken and there's been, I suppose, additional effort put on top of that data to generate new intellectual property. That can be preserved, and it should be preserved. And it's inferred data versus raw data. So there is a piece there where there's the possibility to look at abstracting the logic layer of the data. So instead of giving clients the raw data, that raw data can be converted into situations or scenarios such as on-device abstraction. So the strategy here is, if, for example, you have high-frequency raw signals, you can turn that into high-level events on the edge, which means that you're not giving away your raw data that's been generated by your intellectual property within the device. So a client can get time-stamped situations such as vibration threshold exceeded level 4, for example, instead of 10,000 hertz happened at a specific time. So the result here is a bad actor cannot use the shared data to train models similar to the models that you built on your particular devices, as they'd lack the high fidelity training data that was utilized to build those types of models. So next slide, please. This is just a bit more information, and these slides can be shared with you, but it kind of looks at the technical requirement and the regulatory objective that's needed, the legal reference and relevance, and the action that can be taken across the different categories there. So the accessibility, interoperability, IP protection, your cloud portability and transparency around the data, and then where there's potential legal reference that you need to abide by in terms of safeguards and compliance and costs that may be aligned with giving people, third parties, access to the data that's been generated on your devices or your machines. And then the potential actions that can be applied across each one of those objectives. Next slide. So this is really, the heading here should really be, how does the EU Data Act impact the AI Act? And if you look at the Data Act, the data itself is the fuel, so it focuses on accessing and ensuring you have the right to get the data from the machine, while the AI Act is the engine. So what does that fuel go into, and what does it drive? So focuses on the risk, so regulating the algorithms that use the data to make the decisions. That's where the AI Act comes in and leverages the data. So the synergy here is the Data Act makes it easier for SMEs to acquire the high quality data sets required to train and validate AI models under the AI Act's safety rules. And the clear distinction here is the Data Act applies regardless if the AI Act is deployed or not. And while the AI Act only applies to specific automated decision-making systems. So there is synergy there between the two of them, but there is a clear Chinese wall between them in terms of how they impact each other. So next slide, and I'm just coming up on my time. So practical first steps today are to do data mapping and audit your products or services that generates data to make them readily available for user requests, so access by design requirements. Review contracts, so make sure that you haven't produced contracts to customers that contradict or conflict with the EU Data Act and provide unfair terms. And then look at your UI, UX, so urgent design product interfaces that allow for access to data to your products and allow access by default. And then also there's opportunity there to protect your data. So when I say protect your data, you can signature your data. So if you've 10,000 hertz as a data point, you call it 10,000.00578 or whatever. And that signature could end up in potential other services or products that you could identify and say that that's actually our data. It's ended up in a product that's copying our product. And that allows you then to be able to showcase that data has been used in an unfair manner. And then if all else fails, contact, as Conor and Hana pointed out, several services across Enterprise Ireland. You also have Irish Manufacturing Research, where we can support on any technical requirements and understanding around the Data Act. Okay, thank you. I'll hand over to Laura.
Thanks, Conor, or thanks, Patrick. So I'm just going to briefly introduce the EDIHs, the European Digital Innovation Hubs, to you, and how their relevance and support aligns to some of the implications that Conor, Hana and Patrick have spoken about. And in particular, the EDIHs have seen significant demand for data management support, with a focus maybe on governance and data analytics. So next slide, please. So the EDIHs are a one-stop shop that are supporting SMEs and public sector organisations to advance their digital transformation, to help to boost competitiveness and resilience in global markets. And that support is offered in the form of access to expertise, training and testing facilities. And they will help organizations to adopt technologies such as AI, cybersecurity, high-performance computing, IoT, and advanced manufacturing. Next slide, please. There are 254 EDIHs across Europe, of which member state companies can access. In Ireland, we have 4 of our own. These were launched in 2023 for a 3-year term, and I'm pleased to say that they will continue for another 3 years from this year, further to the announcement of an additional €23 million in funding. So the 4 EDIHs are CEDAR, based at UCD, and this hub focuses on supporting AI transformation in SMEs and public sector organisations. The second EDIH in Ireland is called Factory Exchanged, and it's actually led by Irish Manufacturing Research, where Patrick is coming from today. And it focuses on accelerating factories to become factories of the future, embracing ecological, digital and societal challenges. The third EDIH in Ireland is called Data to Sustain. This is led by Atlantic Technological University in the west of Ireland. Data to Sustain will enhance the transformation capacity of SMEs in the northern and western regions, and focuses on circular economy, operations and sustainability. And the fourth and final EDIH in Ireland is called Entire, led by Tyndall National Institute, based in Cork in UCC. And this hub will support SMEs to become more competitive using digital technologies such as IoT and sensors, but also with a focus on cybersecurity and ag tech. And it's really important to note that these EDIs are strategically important, both from a national and European perspective, supporting policies and strategies such as the soon-to-be relaunched Digital and AI strategy from the Government of Ireland and the EU's Digital Decade, and also the newly launched Apply AI strategy launched last October by the Commission, emphasising European solutions and open source models to enforce digital European sovereignty. So next slide, please. So who are the EDIHs for? Well, they're for any company of any size up to mid-cap. So this company should be trading and have available de minimis balance. And I can talk a little bit more about that later on if questions arise. It is available to both exporters and non-exporters, companies right up from sole traders to DAX, CLGs. So it's a really broad support available to many. The EDIs offer support under 4 specific pillars, and services include access to testbed facilities, access to training, upskilling. For example, there's a course available online and free to access on the EU AI Act, and to date over 3,000 learners have accessed that support. Typically the supports are not IP generating, so it's very much a service-based support, but those services are up to 100% discounted under de minimis. And it is relatively easy to engage with the EDIHs, no contracts involved, as I said, not IP generating. So it really is just a one-pager that's completed by the client on engaging with the EDIH, and that's really referencing the amount of available de minimis aid they have left to them. Next slide, please. So just to give you a sense of some of the supports, and these really, I suppose, respond to some of the comments that the earlier speakers made. These 2 case studies that I'd like to just briefly share with you have both been delivered by Data to Sustain, led by ATU in the west of Ireland. The first one was Data to Sustain, working with a supports management platform. And they were operating across 4 different jurisdictions: Ireland, Canada, the US, and the UK. And their core challenge was that their data lived in silos across systems like Jira. And that meant really a lack of unified access for athletes, coaches, and organizations to reuse their own information. And there was no interoperable data layer to connect tools across the jurisdictions with multiple controllers and processors involved. So GDPR compliance remained an extremely big challenge. And the solution was to develop a retrieval augmented generation chatbot that acts as a unified data access layer. And the users were then able to ask natural language questions to retrieve analytics, event data, and organizational records instantly. And behind the scenes, a scalable API architecture was developed to connect multiple data sources and ensure responses are accurate across regions. Crucially, the system was led in a privacy by design modality, using strict role-based access controls so that all data and all data sharing remained GDPR compliant in a multi-stakeholder, multi-jurisdiction environment. Next slide, please. And another example, again, coming from the Data to Sustain EDIH in Sligo, was a case study looking at a healthcare technology company supporting hospital operations, including revenue cycle management and patient admissions. One particular hospital in Galway faced a major challenge in that every insurer, every hospital system, and every third-party biller used different data formats. And that lack of standardization made interoperability almost impossible. There was no way to ensure that claims shared or data on claims was shared between hospitals and Ireland's private medical insurers. So teams resorted to manual file transfers. And on top of that, the private medical insurers regularly updated claim rules without notice, which led to unavoidable claim rejections because the hospitals lacked the transparent, standardized data exchange mechanisms. And because all of this involved sensitive health data across multiple stakeholders, maintaining GDPR compliance was extremely complex. The solution was to deploy a multi-agent AI system that uses optical character recognition to extract and classify data from varied invoice formats and standardize it. So back to Conor's point about data being machine readable. And this feeds into an automated data transfer pipeline that lets the hospitals and insurers share claims seamlessly. Next slide, please. So just finally, if any of that is of interest and you'd like to get in touch, the contact details for the 4 EDIHs are listed here, as well as the central inbox at Enterprise Ireland for any queries you might have. Lots of activities and events throughout the year planned for this year and the coming years. One that might be of interest that's due to happen soon is on the 25th of March in the Midlands Park Hotel in Portlaoise, which is an IoT Gateway cluster event. So the EDIHs will be presenting at that if anyone would like more information. Thank you.
Laura, thank you very much. And thank you very much to Patrick, Conor, and Hana for your contributions this morning's webinar. We have a little bit of time for questions, but I hopefully people got a flavour today of what's coming down the line with the Act. I think one said to me before, data is the only asset that doesn't wear out. So look at the EU Data Act itself is going to have implications. There's a few questions here that we can talk. Maybe Conor or Hana, maybe you can answer this one. It's how do the exemptions for SME work under Article 7?
Thank you, Fergus. I'm going to take that one. So basically, micro and small enterprises are largely exempt from the Chapter 2 of the obligations, so on B2C and B2B data sharing, unless they are linked to larger enterprises. And medium-sized enterprises benefit from a transitional period, and they are exempt for 1 year after placing a product on the market or after qualifying as medium-sized. However, this is a temporary relief. So medium-sized companies should use this time to build internal technical systems for data access and update pre-contractual transparency documentation and review also contractual data sharing clauses. And the exemption delays compliance, it does not eliminate it. So early preparation is always key and strategically very advisable.
You're on mute, Fergus.
Thank you very much, Patrick. Just a final question, and there's been a couple of similar questions on it. Will the enforcement look like GDPR, or will it be something entirely different?
Thanks very much, Fergus. I'll take that one. Yeah, so enforcement of the EU Data Act in Ireland is likely to resemble the approach taken like GDPR in institutional terms. So you'll have your national competent authorities will be designated, and they'll have their powers to investigate complaints, require information, and then impose those administrative fines. But the key distinction is probably the subject matter, which, you know, GDPR enforcement centers on personal data and individual rights. The Data Act addresses access to and use of industrial and connected product data, your unfair contractual terms in B2B relationships, and cloud switching obligations. So enforcement is likely to include, I would say, a broader mix of regulators. So potentially including your competition or sectoral bodies, rather than relying solely on the data protection framework that's there for GDPR.
Great, thank you, Conor. I think that's it for this morning's session. I just want to thank everybody for their input today. I want to thank Conor and Hana from Vulcan Consulting, Patrick from the IMR, and Laura Clifford for that lovely overview of the EDI programs, which have been a big success. As I mentioned at the start, this is the 5th of a 6-part series of webinar where we're trying to deconstruct some of the more complex policies coming from the EU. So I hope you'll join us for the final session over the coming months. We'll be in touch with details later about that. Just want to thank you all again and have a good afternoon. Take care. Bye-bye.
Thanks, Fergus. Bye-bye.